I
I'll rush
appreciate
it.
the league's engagement with me. Thank you for your patience, sir.
Thank you, Honorable Chair, Senate Budget Committee members. My name is Felipe Hernandez, and I'm the Mayor Pro Tem of the City of Watsonville. And of course, I'm here to strongly request opposition towards the May revised version of the draft bill being considered by your committee. Despite direction from the subcommittee to DOF to eliminate retroactive and harmful provisions, there has been virtually no changes to the new bill that would reduce its negative impact on cities like Watsonville in particular. In fact, the lack of significant changes from the prior bill is even more evidence as to why the proposed language to retroactively exempt DOF from Administrative Procedures Act and to significantly limit successor agencies' financial ability to challenge the DOF interpretations continue to be objectionable to the city of Watsonville, and that's why Watsonville is urging you to reject the proposed bill in its entirety. The city of Watsonville is a state-recognized economically disadvantaged community. Our population is generally about 87% Latino in Watsonville. Our city's unemployment rate currently is at 23.2, and over 21% of our residents live below the poverty level. You know, general improvements that's been happening around with the economy throughout the state and the state's own fiscal situation has had little impact in our mostly agricultural-based community. On average, it's about $15,000-$16,000 average pay for our farm workers. And you know, I wear the strawberry pin still because it is, you know, the strawberry capital of the world there. But just like Mexico, the pay is low there too. In the early 2000s, Watsonville's RDA committed all of its available resources to the development of the Watsonville Civic Plaza. That includes a county superior court and a new library. We had our county seat before had the courts, and it was a real issue to the population of Watsonville to, you know, cross over sometimes an hour drive to get there. So that's why we, you know, the previous council moved to do this. Funding for this $40 million RDA project included loans from the city. In 2006, the city and its RDA entered into 2 public improvement financing reimbursement agreements totaling approximately $4.4 million. The city advanced these funds on behalf of the RDA, which were immediately committed and paid to third parties involved in the construction of this project. The city loaned the funds for this project in full reliance on the future repayment of the loans by the RDA. The dissolution of the RDA had a huge negative impact on Watsonville's efforts to address its economic development needs. However, Watsonville relied on AB 1484 incentives and written and oral assurances from the DOF that these long-standing city RDA public improvement financing agreements would qualify for reinstatement upon issuance of a finding of completion. And as I was saying, acting on that assurance, the Watsonville paid out over $4.4 million to the state to meet the DOF's conditions and received its finding of completion. It was a shock to us when, after paying $4.4 million and complying with all the DOF's requirements, the DOF denied reinstatement of the $4.4 million public improvement financing agreements based solely on its apparently new interpretation of the reimbursement agreements are not loans. DOF had never before raised any questions regarding these agreements, and in fact had always clearly referred to both public improvement financing agreements as loans that could be reinstated. You know, after Watsonville received no response to its request to meet with DOF, the city had little alternative but to file suit in Sacramento Superior Court. And on June 16th of 2015, the court ruled in Watsonville's favor relative to these financing agreements and found that the reimbursement agreements were loans and were eligible for reinstatement. In the proposed budget trailer bill, the DOF is including a new loan definition that specifically excludes reimbursement agreements as being eligible for reinstatement, and further proposes to make provisions retroactive. DOF's blatant attempt to legislatively reverse the court's decision also supports its interpretation that reimbursement agreements are not loans. There has been absolutely no change in the language in the May revised version of this draft bill than the prior bill. Using the legislative process to retroactively negate court decisions is neither appropriate nor fair. The loss of $4.4 million to Watsonville, when combined with other additional negative impacts that other provisions of this proposed trailer bill could have on Watsonville, accounts for approximately 20% of our general fund budget. This would have an overwhelming financial impact that would affect the city's ability to provide basic essential public services. Given significant impacts to our community, Watsonville respectfully requests that you oppose the May revised trailer bill as drafted. You know, we're in a situation right now in Watsonville where we're considering even eliminating our summer lunch programs for young people at the parks. I had to run around all day yesterday trying to raise funds to continue our summer lunch programs this summer for kids that can't afford lunch. You know, so it's really going to affect Watsonville negatively if we lose this $4.4 million. Thank you.
Thank you for taking the time to come up here. I don't want you to ever think that we don't value your testimony or your viewpoint or the facts that you provide to us to try to inform our decision. This can be an intimidating environment even for local elected officials, and I just appreciate the fact that you choose to come up here and speak to us.
Senator Roth, I just wanted to add that, and my colleagues and associates can agree that our experience with the Department of Finance has been terrible in terms of trying to mitigate some of these problems. Absolutely terrible. So thank you.
Well, I'd like to think that our friends in the Department of Finance have taken a substantial step here in trying to, remedy some uncertainty. There are some issues that you've identified with interest rates and with reimbursement agreements, but it's the first step on the long road to rehabilitation.
Thank you for your time.
Thank you. Okay, ladies and gentlemen, you see the line, so feel free to come up here or stand by the mic. If something has already been said, I'd ask that you just echo the comments. If you need to say something in addition, I certainly will here to listen.
Good afternoon. Oh, are we good? Good afternoon, Chairman Roth and members of the committee. My name is Randy Knott. I'm the Government Affairs Director for the City of Sacramento. I stand here in solidarity with the League, although we don't have, at least not anymore, as many issues as some of the other small cities. Just listening to my former employer, the City of Glendale, many moons ago, $45 million. We have an entire annual budget in the City of Sacramento of $115 million, so it's very, very significant. That said, my points are a little more particular. One of our major issues with the proposal is that the property maintenance issue, there was some movement on graffiti abatement. All of your staff lives here. The Department of Finance staff lives here. We have other issues besides graffiti abatement coming out of this recession and needing to clean up. We obviously have a large transient population in downtown Sacramento. This is the capital. Many of these properties, the city will have to go into its general fund to keep up. The proposal also allows for only one amendment in the long-range property management plan, and that one appears to only apply to public parking. We believe that that is very short-sighted, and we need some additional flexibility as we try to continue the transition. Lastly, a single annual ROPS sounds like a great idea. I only have to go through this once. Then again, we have other opportunities, and it really restricts flexibility. If we can't go back and amend the ROPS, we can't get the best possible deal, not only for our city, but for the state. And lastly, we are very, very concerned that the proposal affects the judicial integrity and frankly, a balance of powers and checks and balances. So thank you for your time.
Thank you for coming.
Thank you, Mr. Chair. David Jones on behalf. I echo the comments of Glendale and Sacramento. Also on behalf of Murrieta, they have $5.3 million at stake in the trailer bill, and they would ask you to remove any provision that deals with litigation. We think it's fundamentally unfair that you've got cities that have won judgments, and this will go and adversely affect their ability to do that. Also, others will talk about the court fees, but for that,
What are we talking about? Reimbursement agreements in
they've got
Murrieta?
loans. Yes, yes. Thank you.
Hello, my name is Christine Carson. I'm Deputy City Attorney for the City of Ridgecrest. I would echo the comments made by City of Watsonville and City of Glendale. The City of Ridgecrest is in a declared state of fiscal emergency since 2012. The city has responded to this crisis with employee furloughs, project cancellations, departmental budget restrictions. In 2010, prior to dissolution, the city loaned the RDA more than $3.5 million for the development of a solar energy field. It's been built. The developer has been paid. Approximately 1/3 of the loan has been repaid. It was a loan for cash, memorialized in writing at a joint meeting. All the terms of the loan were set forth in a resolution approved by both the RDA and the city. The problem that we have, one of the problems that we have with the current May revise is that it would redefine what a loan is under California law. In the City of Watsonville case, the court used the California law definition of what a loan is. It applied California law to determine whether or not it was a loan. And under the current language, a loan would be redefined, and essentially loans between city and RDAs, many of them would not be enforceable under the new language. This would have a huge impact on the City of Ridgecrest, which is in a state of fiscal crisis. Their revenues and budget are approximately $11 million, so a very small budget. With a shortfall of more than $2 million, this could cause layoffs, departmental budget cutbacks, elimination of essential city programs. And since the departments are working with skeleton crews presently, the greatest impact would be to public safety. So the City of Ridgecrest is opposing the May budget revise. We also have concerns about the language about the Administrative Procedures Act and curtailing the funding that the city could have because it's currently in litigation on 2 determinations by the DOF.
So what is it about your cash loan from the city to the RDA that is not valid? From your understanding?
It is valid. Our point of view is that it is a valid and enforceable loan. However, under the current language of the May budget revise, it would redefine loan agreements and state that loan agreements do not include agreements that the former RDA was required to repay to a city for costs of services or obligations incurred under contracts with third parties. I mean, that's what the language says. It's somewhat vague, but we think that the DOF would rely upon it to try and change the definition of a loan. Under the Watsonville decision, the court applied the plain meaning of the term loan under California law and found that, loans between cities and RDAs, if they meet the definition of a loan, are loans.
Okay.
So that is a concern in a city that is operating on a very small budget and fears that, this would impact public safety if they have a shortfall of in excess of $2 million.
Thank you. Thank you for your comments. Sir.
Mr. Chairman, members of the committee, my name is Brent Hawkins. I'm an attorney with Best & Krieger in Sacramento. I'm something of an endangered species. I've represented redevelopment agencies for approximately the last 40 years. I'm here on behalf of 2 cities, the city of Fontana and the city of La Habra, because they are concerned about the provisions of this bill that would further erode the already inadequate protections that exist in the law against arbitrary decision-making by the Department of Finance. It would do this by first exempting the Department of Finance's decisions under the dissolution law from the rulemaking procedures under the Administrative Procedures Act, and second, by requiring litigation costs to be paid from the administrative cost allowance. Let me give you just, and I'll be as brief as I can be describing what is a very complex situation, but one example of the kind of arbitrariness that these cities and many other cities have had to deal with. In 1982, the Fontana Redevelopment Agency and a private developer entered into an agreement to finance public infrastructure that was needed to develop several thousand homes. The infrastructure included not just backbone street sewers and waters, but also schools, fire stations, and regional serving facilities. Under the agreement, the private developer would front the entire cost of this infrastructure and be reimbursed with interest over time by the redevelopment agency from the tax increment that was generated from the project. To assure the developer and his lenders and investors that the redevelopment agency's reimbursement pledge was binding, the financing agreement and 3 amendments to the financing agreement were validated by court judgments, which found that the agreements were just and lawful and the provisions were reasonable. Just earlier this month, the Sacramento Superior Court issued a decision in which it specifically found that the financing agreement was a valid enforceable obligation under the dissolution law. The developer completed the construction of the project, including the public infrastructure, in 1992 at a cost of nearly $200 million. The developer has been receiving annual reimbursements under the agreement and has so far received approximately $170 million in reimbursements. When the Fontana Redevelopment Agency was dissolved, the successor agency listed the obligation to reimburse the developer under the financing agreement on the semi-annual ROPS, the Recognized Obligation Payment Schedule, which was approved by the Oversight Board and the Department of Finance on multiple occasions over the past 3.5 years. Just last week, Fontana received a final determination from the Department of Finance that despite its previous recognition of the financing agreement as an enforceable obligation, the 4 validation judgments holding the agreement to be a valid enforceable obligation, and the recent Superior Court decision holding the financing agreement to be an enforceable obligation, the Department of Finance would no longer recognize the agreement as an enforceable obligation and would not approve the allocation of property taxes needed to pay the obligation. The primary reason for this determination by DOF is its claim that Fontana has failed to provide it with adequate documentation. In fact, Fontana has provided the department with everything they've asked for, including multiple binders full of documents, and DOF's explanation fails to account for the fact that it obviously had sufficient documentation to approve the agreement multiple times in the past 3.5 years. I raise this issue not because I expect the department to fix it. There's a legal process for that. But because it illustrates how arbitrary Department of Finance has been in administering the redevelopment dissolution process and how ill-deserving it is of even greater authority as proposed by this bill. With Department of Finance, nothing is ever final, and its previous actions can never be relied upon as a predictor of what it will do in the future. Doing business in this environment is impossible. It creates such uncertainty that it is impossible to budget or plan more than a few months at a time. Fontana urges the committee to reject the department's budget trailer bill, not because the existing dissolution process is working so well, it isn't, but because this bill would only make it worse by giving the department greater authority when it has shown itself incapable of fairly exercising the authority it already has. Thank you.
I will say, with respect to the Administrative Procedures Act, that I'm clearly, generally in favor, and I could say clearly in favor of transparency in the use of the APA. But what I'm bothered by with all this conversation about the APA, if we were to say today that the Department of Finance to promulgate some regulations and go through the Administrative Procedures Act process, when would that end? And aren't we going to be finished with this conversation by the time they promulgate regulations and have them through the hoop and published?
Senator, I wish I shared your optimism about how quickly this process is going to wind up.
Well, I'm just concerned a state that has budgetary challenges even today and probably more so in the future. I just wonder if that expense is worth the effort. The other issues, it seems to me, are certainly clearly defined and probably need to be addressed. You mentioned this reimbursement agreement. This agreement with the developer is implicated by the
No, this is different. This is an agreement between the former redevelopment agency and a private developer, not with the city.
Okay. So your issue really is the Administrative Procedures Act process.
Well, it's the, how do you explain what has happened here? We can't.
I get it. I understand.
Okay.
Thank you for your presentation. Yes, ma'am.
Mr. Chair and members, Sylvia Solisha on behalf of the City of Santa Monica. We currently have some concerns with the revision to the trailer bill language pertaining to the interest rate, to the issue of the 2011 bond funds, the County Oversight Board language, particularly that in regards to LA County. But today, in the interest of time, I'd like to focus my comments on the language that is pertaining to the change in the definition of loan agreement. For Santa Monica, I think that would be our priority issue. We believe that the new definition, if adopted, would preclude a city's ability to get loan repayments on most, if not all, of our loans, because most loans were made upon transfers of real property or capital assets to the RDA for redevelopment purposes. The reality is that cities were organized and operating with full public works, real property, and contractual service department. It was more efficient to transfer those assets to the RDA in lieu of general fund cash transfers. So, consequently, also, former redevelopment law authorized RDA payments for publicly owned land and capital facilities. So most loans ended up being transfers of non-cash assets. Again, we believe that the current interpretation of loan agreement would literally require a cash transfer of general funds between the city and the RDA and would exclude almost all loans as we understood them to be allowable under AB 1484, and that was one of the carrots in that legislation. So we would like to suggest the following revision to the loan agreement language to mean loans for money entered into between the former RDA and the city, under which the city transferred money, capital assets, or real property to the RDAs as previously authorized under Section 33445, as we believe that would capture the transfer of capital and property assets. So we appreciate that. And we also appreciate the fact that Mr. Hill has mentioned that the door is open for further discussion on some of these issues, and we plan to communicate our proposed amendments to him. Thank you.
Well, ma'am, before you leave, let me just make sure I understand. So in the case of, this is Santa Monica?
Yes.
In the case of the city of Santa Monica, each of these transactions was not only supported by, I assume, a resolution, but fully documented in terms of an agreement?
Yes. Thank you.
Mr. Chair, Senators, Alan Fernandez on behalf of the Los Angeles County Board of Supervisors, here to express our concerns. Right now, we're actually working towards an opposed unless amended of the draft that we received late last week. Incidentally, we did have a support in concept for their first version. I do want to say I appreciate Department of Finance addressing a couple of issues that weren't previously addressed. However, I want to spend time talking about two issues because it hasn't really been discussed thus far. That is with regard to the consolidation of oversight boards. In Los Angeles County, we appreciate the acknowledgement by the Department of Finance when you have an area, a region of the state that has more than 40. We have 71. We have over 400 properties outstanding. So clearly, at the inception of the dissolution of redevelopment, when we threw out a date into the future to consolidate into one, we had an inkling that that might not work for larger counties with much more property to dissolve and dispense with. And I think now the Department of Finance is realizing that. However, the approach we think makes it much, much more complicated than need be. There is a bill in the legislature on the Assembly side that recently passed 78-0 that takes up this issue of how to handle when we have a county that has many redevelopment agencies. We can simply either extend the date out, we can allow the successor agencies to seek and pass a resolution extending them for a period of time to allow. But the proposed solution in the trailer bill, we think, makes it extraordinarily even more complicated. We've talked ad nauseum about how complicated this is to begin with, but the trailer bill would have a consolidation up to 5 oversight boards in a county based on the supervisorial jurisdictions. As you know, some redevelopment agencies cross over multiple jurisdictions. Indeed, in LA County, there's at least one, the city of LA, that has all 5 supervisorial districts. Then you get into the question, well, what if the properties in one that are remaining are in one supervisorial district, but the bulk of the territory for the redevelopment is in another? It would have the county sort of sift through that mess and discern which, jurisdictional boundaries would be the oversight board for that particular RDA. We think it's overly complicated. We appreciate the attempt to solve that problem, but again, there are other pieces of legislation, and we believe other more elegant, easier ways to handle that particular problem. So that's a significant concern for us. In addition, the way that this trailer bill proposes to address the 2011 bond proceeds, the so-called Mardi Gras period, is another area of concern to us. We're still analyzing that and seeing what the tiered approach looks like for us from a fiscal perspective. And so I don't have a specific solution as I do for the other one in AB 204 for the 2011 bond proceeds, but I do want to note that we are concerned about that provision, and we'll hope to work with finance and you all in addressing that.
Just so I understand, what's your solution again for the countywide oversight board proposal, to leave it with local jurisdiction?
Well, yeah, currently AB 204, like I said, that just passed the Assembly 78-0. It's on your, it's coming your way.
Well, we don't,
Yeah.
yeah, you have to tell me, I don't know.
Okay, well, what it does basically, well, it only applies in LA County, where, as I said, there are 71 redevelopment agencies and oversight boards outstanding over 400 properties.
So what does it do?
It allows basically the successor agency, if there is a bulk of property to, that needs still obligation payments, to pass a resolution, provided they meet certain criteria, to extend the date that we put in, I think it's 1484, to operate past, for another year.
So the solution is to leave it with the local oversight boards?
Yeah.
Okay,
Thanks.
got it.
Okay, thanks.
Thanks for your time.
Good afternoon, Mr. Chair,
Yes, sir.
Senators.
Thanks for coming.
Thank you. Jonathan Clay on behalf of the City of Coronado. We're one of the cities that have been prevailing in the courts on the re-entered agreements. We appreciate that the original trailer bill language related to the re-entered agreements is coming out. We share some of the concerns of the League of Cities on making sure that the language within the trailer bill is cleaned up. We have concerns about interest rate, how that's going to be applied, especially for those of us that had been prevailing through the courts. And I think the issue that I just want to highlight for you as you look at this trailer bill is, for a jurisdiction like Coronado, being able to get its loan repaid is very important. The ROPS letter that we got at 11:59 on Friday night was about as clear as mud in terms of our understanding of how this is going to move forward. We're reaching out to Finance AG's office relating to money that the judge had set aside for repayment. I think from Coronado's perspective, we're concerned that this looks like it may take a very long period for the repayment. We're not sure. The interest rate we think is 0% or something close to that. And so we think those are some issues that the courts were addressing that we think are being prejudiced some way within this trailer bill language. Again, we look forward to working with finance and the legislature as this process moves forward, but we just want to at least put those concerns on the table as we
Right,
talk about
primarily
this.
interest rates.
It's interest rate, but also I think from Coronado's, we'd love to see this loan paid back more quickly, just get it off the books so we can shut down the redevelopment agency. Based on what we think was in the ROPS letter, this is going to take out to 2036. So we would like to try and deal with that sooner. Thank you.
Yes, ma'am.
Good afternoon, Mr. Chair. Karen Lang on behalf of a few different local governments that actually are in support of the trailer bill. I'm not sure if I should be in this line. Stanislaus County is heartily in support of the long-term problem that is now being rectified called negative bailout. It has to do with the formula that was enshrined in the statute in the post Prop 13 passage. The county's been working for decades to try and fix that. They're so thankful that the governor and Department of Finance have included that. The city and county of San Francisco are in strong support of the trailer bill. To your point earlier in the hearing about winding down as quickly as possible and what Department of Finance is trying to achieve, the language that is included in the trailer bill will actually assist San Francisco in meeting their obligations, their enforceable obligations sooner as it relates to affordable housing. So if they can build it sooner, they can get out of Department of Finance's life a lot sooner. And the way that they would currently accrue the money would mean that they're going to be in operation for decades still, just because of how long it would take to build that affordable housing otherwise. So they're in strong support as well. Sonoma County did have concerns in a previous version of the trailer bill. They're very thankful that the lawsuit has gone away. That was announced last week after the May revision came out. They're still trying to square a few things away with the lawyers, but in our view, on behalf of Sonoma, Stanislaus, and San Francisco, they are in support of the trailer bill. Thank you.
Thank you for joining us. Yes, sir.
Mr. Chairman, Senator Pan, Philip Lansfame with the City of Glendale in opposition to the bill. You've heard many of the issues that I oppose from a technical and legal perspective, namely the definition of loan and the interest rate issue. So I want to direct my comments to fairness. The citizens that you represent are suffering at the local level. We've done everything that has been asked of us, and in response, we're now going to lose the repayment of a legitimate loan that was promised to us with 1484. In the city of Glendale, this year we experienced our first surplus in almost 10 years. And if this bill were to pass under the current terms, we will go back to deficit. We have made all the cuts that we can in the quality of life areas. We are down to police and fire. We would lose our entire library system, our entire park system, if we are unable to repay the city for these loans. We will go deficit $5 to $7 million for the next 5 years until PERS rate starts to stabilize, and then we start to see go back to positive. So in all fairness, I urge you to reject this bill, allow the cities to be repaid under the terms that were promised to us in 1484. Thank you.
Thank you for coming.
Good afternoon, Senators. Anthony Newman with the County of San Bernardino. Our opposition is actually on a provision in the trailer language that would expand the role of the current county controller auditors. The concern is that you take a neutral third party, being the controller right now, and throw them onto the oversight board, have a staff it, which turns into a conflict of interest. It opens up the county for potential liability risks of litigation.
Okay, thank you, sir.
Matt Ballantyne, City Manager for the City of Chino. We share the same concerns as Glendale. We had we had some promissory notes between the city and the RDA, and at the tune of $15.4 million. And those were for some sewer and storm drain projects that were desperately needed in the project area. And as far as interest, we stand to lose roughly $3 million. And it's in the promissory note that the interest rate is based on the LAIF rate. Thank you.
So your point has to do with the interest rate on loans.
Well, the loan first.
Over
the loan takes, I mean, that's a lot.
Is it your understanding that even though you have a promissory note, as we define that in California, that that's invalidated?
That's the concern based on the trailer bill.
Okay. Got it. Thank you.
Good afternoon, Jerry Craig, City of Tustin, and thank you for this opportunity. City of Tustin opposes this bill. After the city reemitted all our unobligated funds, we asked the Department of Finance for a finding of completion. We were denied that finding of completion, and we had to go to court, which we prevailed. Under the law, as it's currently written, DOF must allow the successor agency to repay over $42 million in loans. We sought repayment on those. DOF has again refused, and we filed a second lawsuit. DOF knows it's on shaky legal ground, so now here we are with the ask of the legislature to change the rules in the middle of the process. The legislature should not assist DOF in this effort to shirk its responsibility to follow the law as it was written and as it was revised by AB 1484. You know, I've been a resident of Corona for 26 years and a proud Riverside County resident. I'm very familiar with Senator Roth in your efforts to restore the funding for those 4 recently incorporated cities, and very supportive of those efforts. But I don't believe, as this bill is written, that $23 million should come to those cities at the expense of the $42 million that is owed to the city of Tustin under 2 different reimbursement agreements that were documented, that were entered into by the city council and the successor agency that had legitimate services and interest rate associated with it.
Well, you've used 2 terms, sir. You've used loan and you've used reimbursement agreements. And since I haven't read the City of Watsonville, I don't know whether there's a way to differentiate between the 2, but I assume we're talking about, when you use the term loan and now you use reimbursement agreements, we're talking about an agreement where the city provides some services to a redevelopment agency and in return at some point expected to be reimbursed, or are we talking about something else for $42 million?
Yeah, we had 2 different agreements. One of them is that the city did public infrastructure improvements with the agreement stating that the redevelopment agency would reimburse the city.
And you have an agreement to that
Yes, sir.
effect plus an ordinance?
Yes, sir.
Or, I mean, whatever.
Resolution.
Resolution.
And then the second agreement was the city of Tustin, which is the home to the former Marine Corps Air Station base. We sold land to a housing developer at a reduced cost to effect the development of over 300 affordable units. And in that, we had an agreement between the agency and the city to reimburse the city for that reduced sales price. So those are the 2 different kinds of agreements, reimbursement agreements, but we believe are loans.
So how did that work? So you sold property to the redevelopment agency at a below market rate to have it developed for affordable housing, and what was going to be the basis for calculating the money coming back to the city?
Okay. We sold it to a developer at a reduced cost, yes, sir.
Okay.
The basis is the promissory note between the market value and the affordable price. So we have very low income, we have low income, and we have moderate income units. And so obviously there's a market rate, and then the difference between what you're selling. If you're selling a home to a very low income individual, that home probably was sold around $70,000, $80,000, and so the gap might have been $300,000 to $400,000. If you sold it to a moderate income homeowner where the price was $300,000, then the gap might have been $100,000, $150,000. So that's how we arrived at how to reimburse the city for those costs.
So the city sold the property to the developer or transferred it to the redevelopment
No,
agency?
City sold it to the developer at a reduced cost to effect affordable housing, ownership affordable housing.
Okay. Well, I'll look into that.
Yeah, so, and what's exciting as a father of a child with Down syndrome, one of the very low-income homeowners is an adult with Down syndrome who works and who's able to live in his own home. So I'm kind of proud of what we did, even though one could, ownership affordable housing is a whole nother story, but it's a lot more complicated than rental affordable housing for communities. We agree with the discussion about the LAIF rates brought forward by the League of California Cities. The challenge, though, is if our reimbursement agreements are not seen as loans, as which we believe they are, then a discussion about LAIF rates doesn't do the city any good. Last but not least, I've sat through numerous meetings with our city attorney and with special counsel and gone through the law and quoted and cited and referenced, but it seems like this all comes down to a basic principle, and that's do unto others as you'd have them do unto you. None of us in this room would want to loan anyone money, whether I gave you cash or I paid for your car to be repaired, if you weren't going to pay me back. We would expect that they would pay us back as much as I would pay them back. And here we are, we're asking for the legislature to eliminate this provision for cities to be paid back, where the legislature would not want to be in that position where they're not paid back. With all the citations and all that other stuff, it just seems like a simple principle. Let's do unto each other as we'd like done to each other. And none of us would want that to happen to us, so why do it to someone else? Thank you.
Thank you. Thank you for coming.
Good afternoon, Mr. Chair. Dorothy Holzman with the California State Association of Counties, hoping to avoid an awkward transition back to local government financing provisions, and want to express our support specifically for the insufficient ERAF backfill, the ending of the negative bailout affecting the 4 counties, the debt forgiveness for California's newest cities, and the forgiveness for the property tax obligations for San Benito. Thank you.
Yes, ma'am.
Yes, Mr. Chair, Jolene DeVoris on behalf of the Urban Counties Caucus. We're still reviewing the redevelopment trailer bill language, and obviously we'll look at the potential county costs and other issues raised at this hearing, but I did want to note also that we are in support of the local government package as mentioned by CSAC. Specifically, we're in support of the newly incorporated cities provision, which will help the county of Riverside, and so I want to note that for the record. Thank you.